For most Canadians, buying a home means securing a piece of the world that is exclusively yours. You hold the deed to the property, you set the rules, and you assume the land belongs to you indefinitely. In legal terms, this is called fee simple title. Under the Torrens system of land registration, fee simple is the most complete form of private ownership. It is designed to ensure that your name on the registry is conclusive proof of ownership, intended to be secure against competing claims. Look at this aerial view of Richmond, British Columbia. This is a dense, highly developed urban landscape filled with commercial centers and private homes, all held under fee simple title. In August 2025, the BC Supreme Court issued a ruling in the case of Cowichan tribes versus Canada. After a 500-day trial, the court officially recognized Aboriginal title over a swath of territory that directly overlaps these exact privately owned urban lots. The court determined that provincial land grants do not automatically extinguish Indigenous land claims. A name on a land registry does not erase the pre-existing legal rights of an Indigenous community. This diagram illustrates a core legal friction. You have two distinct legal regimes: fee simple ownership and Aboriginal title. Both systems grant their holders the right to 100% exclusive use, occupation, and control of the land. You cannot have two different groups exercising absolute exclusive control over the same physical parcel at the same time. If one group has the right to determine how the land is used, the other group's similar right becomes impossible to exercise. This conflict leaves private landowners, governments, and First Nations facing an unresolved legal situation where two valid rights occupy the same space. To understand the clash, we have to look at how these regimes differ. Under the fee simple column, ownership is an individual right. It is alienable, meaning you can sell it to anyone, and it is governed by standard common law and provincial statutes. In the Aboriginal title column, the right is held communally by an Indigenous group. It is inalienable, meaning it can only be surrendered to the Crown. And because it is a right to the land itself based on historical occupation, it isn't something granted by the government. This photograph captures the signing of the Constitution Act of 1982. Section 35 specifically recognized and affirmed existing Aboriginal and treaty rights in Canada. Because Aboriginal title is entrenched in the Constitution, it carries a weight that provincial property statutes, like a Local Land Title Act, cannot easily dismiss. The BC Supreme Court ruled that fee simple and Aboriginal title can legally coexist, but that Aboriginal title is the prior and senior right. The judge did not order the immediate eviction of private homeowners. However, by declaring that the original Crown land grants were invalid, the court ruled that Aboriginal title continues to legally burden the fee simple land beneath homes. The court's remedy was to direct the provincial government and the Cowichan tribes to negotiate a way to reconcile these competing interests, leaving the final status of private properties dependent on future talks. 4 months later, a court on the opposite side of Canada arrived at a different conclusion. In the Wallace-Stoke case, the New Brunswick Court of Appeal ruled that Aboriginal title and private fee simple ownership are legally and practically incompatible. In their view, they cannot coexist on the same parcel of land. The New Brunswick Court decided that innocent private landowners should be left out of the lawsuit. They stated that if Aboriginal title is proven over private land, the appropriate remedy is financial compensation from the government, not the return of the land. The Canadian justice system is now split. Depending on the province, courts have established opposing rules for how constitutional Indigenous rights interact with private deeds. This legal division is moving from courtrooms into the national economy, affecting local municipalities, homeowners, and long-term industrial projects. When the underlying validity of a property right is questioned, financial institutions react. Lenders become hesitant to issue mortgages, and developers face difficulties securing insurance or investment for projects on contested land. On the other side of the issue, Indigenous communities are fighting for the return of unceded territories, lands that were historically surveyed and sold by colonial governments without their consent or a treaty. A modern economy relies on clear land titles to function. Systemic ambiguity makes it harder for lenders and developers to calculate the risks of long-term projects when the highest form of ownership is subject to a senior legal claim. This is the interior of the Supreme Court of Canada. With lower courts issuing contradictory rulings, these cases will inevitably be decided in this room. The justices will have to deliver a nationally binding decision that establishes the legal priority between Section 35 constitutional rights and the private property system. They must find a way to reconcile centuries of colonial land grants with the modern enforcement of indigenous constitutional protections. The upcoming ruling will define the exact legal hierarchy between two competing constitutional interests, providing a final answer to who holds the ultimate right to the land.